the criminal ID bill, by which the central government will be, or the police forces will be able to store data on people they feel have a criminal background. Now, many of the opposition parties felt, when this cleared Lok Sabha through a voice vote, that minus a data protection bill, this is going to be a privacy nightmare. I would like to introduce our guest, N.S. Napinai, advocate in Supreme Court and founder of the Cyber Sathi Foundation, and Subimal Bhattacharya is a cyber security expert. Let's know your views. N.S. Napinai, what is your view?
I am deeply concerned because you already had an Identification of Prisoners Act. It went through amendments. After a law commission report went into what was the requirement, and it has limited the kind of data that can be collected. You have to keep in mind, Sanket, that what is being sought to be collected is not just from convicts, but also from persons accused. And you have a provision which says if the offense that is being accused of is less than 7 years, then you cannot be forced to give this the details that are being sought. The wording that is used is measurements, but what is being taken is actually a lot more than measurements. It's everything from your physical, physiological, psychological, etc. profiling. The reason I mentioned about the 7-year sentence aspect is, if I were to ask you, if I just throw a section from IPC at you, Sanket, and ask you, how many years sentence does it carry? Would you know that? You are, if it's a person who is being arrested on the accusation of having committed an offense, he is not yet a convict, and he is being asked to surrender a lot of personal details without understanding what his rights are. It's not like he's going to have a lawyer in tow to tell him what is the applicable provisions and what are the sentences that are going to apply to it. And unless somebody is there to tell him, look, you have the right to remain silent, you have the right to not provide these details, he is not going to know. And in a circumstance like this, where it is mostly out of fear that a person in that situation would be conducting himself, to expect him to be able to protect his two very important rights, which is his right of privacy and his right to not self-incriminate. So I feel that two very important decisions of the Supreme Court have been completely ignored through this bill. And as you rightly pointed out,
right to privacy.
We don't have the Personal Data Protection Act coming still, and this has taken primacy before that.
Now, Subimal Bhattacharya, how would you respond? You've heard what Ms. N.S. Napinai has to say, that you've got a right to privacy, law or a judgment from the Supreme Court, which doesn't seem to be respected with a law like this. And of course, the fact that we still do not have a personal data protection bill. It's been in the works for many, many years.
Absolutely, Sanket. I think the personal data protection bill has taken a lot of time, and definitely the government should be far much more proactive to, make it as a law. But having said so, we are still not operating in a vacuum. There is an IT Act. There are other acts, as Advocate Napinai has also mentioned, the IPC. You have the information technology guidelines that were passed in 2011 itself, which took care of the basic privacy aspects of citizens. So I think we are not operating in a vacuum. And having said so, what this current bill intends to do, basically so much of technological changes are happening. Technology is being used so much more today in the criminal justice delivery system, and particularly in investigations. So here in this case, when you are trying to amend a 1920 Act, of course it has had its amendment, but even if you look at the 2003 expert committee that was put up, they had also proposed, looking at the availability of technology. They need to take samples that could be far much more definitive in nature. So I think,
No,
you know,
no,
as we move ahead
my
with
point over
technology,
here
we have
is,
to-
you heard Ms. Napinai, her main concern was how this technology will be used. You can put it to good use, you can misuse it as well. Now that is true for every law in this country.
Yeah, absolutely.
But the point is, this is data privacy. The point that a person who even before conviction is going to let go of some very important personal data.
So even today, if personal data has been submitted, you know, they are not, you know, meant to be strewn around here and there, or subjected to all kinds of misuse and all. I don't think such intent has ever been there from any government. So pending the fact that the data protection bill is in works,
No,
should be...
intent and provision in law are two different things, Mr. Subimal. The point is, the government may have great intentions, but by law, a person must be protected that this data will not be misused. It should be in the law. I think otherwise, you know, everything can be left to intention. You don't need laws then, after all. Everything will be on good intentions. Anyway, the point is that this has cleared the Lok Sabha test. It is yet to clear the Rajya Sabha test, where it will eventually come up. There are a lot of MPs who are saying you give it to a select committee. Let's put more thought into this. Let's discuss this and then implement a better bill. What will the government
Sanket, may I come in for
send
just
it to a
1
select
second?
committee or railroad through? I've run out of time, Ms. Napinai. I promise that we are going to debate this and get more views as we go along when this gets presented for tabling in and passing in the Rajya Sabha as well. That's a wrap in this edition of Breaking Views, but news continues on the other side. Stay with us.